Welcome back to the morning show here on Arise News. The Code of Conduct Tribunal, the CCT, yesterday rejected the request by the Chief Justice of Nigeria, the CJN, Justice Walter Onnoghen, to adjourn his trial indefinitely. The tribunal chairman, Danladi Umar, said the tribunal was not constitutionally bound by orders from both the High Court and the NJC because Section 306 of the Administration of Criminal Justice Act, the ACJA 2015, forbade the grant to stay of proceeding in criminal matters. Now, joining us to speak on this and several legal issues arising from the CJN's ongoing trial is a constitutional lawyer, LIBOROUS OSHOMA. Thank you for being here.
My pleasure.
Now, this case has generated so much hype and hue.
Yeah,
we've had opinions from many legal luminaries, including the NBA. Let's get your stance on this matter now. Is the CJN in breach of the Code of Conduct Act, Section 15? It's a very simple matter.
You know, when matters are in court, we don't make comments that will be prejudicial to the eventual outcome. But if you look at, in reading Section 15, you also need to read Section 3 of the Code of Conduct and Tribunal Act also. You can't read one in isolation. It needs to be taken holistically.
Together.
And so Section 3 of that Act says that if the person in breach admits in writing, there shall be no recourse to the tribunal. You can Google it. That's the provision of Section 3.
That's a new one. We've not heard that said anywhere.
A lot of people, because I think these are arguments that will come up in the course of the matter. You know, so, but that's not to take away, you know, the gravamen of the issues that are in the public domain. You know, not long ago, if you remember the Justice Naron and Otumba Kalajaye saying, you know, issue at the Election Petition Tribunal in Osun, then late Justice Kayode Esho, of blessed memory, did raise an alarm that the way we were going, we were gradually creating billionaire judges who, even if at the end of the day you ask them to go, you know, they will gladly walk away. You know, and so you find that over time, the politicians, for desperation and the brand of politics that we practice, have consistently, you know, taken steps to, you know, undermine judicial process and corrupt judicial officers. You know, so all of these are, you know, issues that are in the public space. But the big question is, in law, the law does not, the law has processes and procedure. It doesn't close its eyes to processes. The first question in law is not about culpability. The first question usually is the processes for bringing presumably culpable people to justice. And a wrong process can see, you know, a thief, quote and unquote, walk home freely. A wrong process also can see an innocent man go to jail. And that's why the Supreme Court put our GS in their wisdom, says, look, we are not infallible, you know, because we are final, but we are final because we're not final because we're infallible, but we're infallible because we're final.
But where does this leave, all of this leave the existing or subsisting Court of Appeal ruling in the case of Ngajiwa versus the Federal Republic of Nigeria? Yeah,
that's why I told you that processes and procedure, that's where it leads it. And you see, I had stated here
over the weekend.
Yes, over the weekend that if I were the federal government, when everybody, almost a lot of senior lawyers are telling you, look, there are processes, follow these processes. And you argue, no, if I follow the process because the CJN, it's the head of the NJC, what's the guarantee that that process won't be compromised? The CJN also is the head of the Supreme Court. So if the matter eventually gets to the Supreme Court, what's the guarantee that it will also be compromised? And so when you assume, take that position, assume that, you know, if you follow the processes, other justices, you know, that will sit on the matter will not be fair. You by, you know, a stroke of the pen condemn the entire system. You know, that's also not too good for the judiciary and then for those judges who, you know, are working hard and also who are above board. And so when you look at this process, you say you want to achieve an aim quickly, time your sleep, because election is around the corner. But if you don't follow the process, you might end up, you know, having to take a longer route when it would have been shorter. And that's why you see, now we are not even talking about the charge itself. What is in court now is at the preliminaries. And I tell you, these preliminaries might eventually get to Supreme Court, because yesterday the court had ruled that it has coordinate jurisdiction in spite of existing rulings, you know, that it has coordinate jurisdiction with the Federal High Court and National Industrial Court, even though the Court of Appeal and the Supreme Court has ruled that the tribunal, no matter how cloaked with powers, remains a tribunal. And so, because that also might, you know, present a grave danger for, you know, or other tribunals, like you have the Chartered Accountant Appeal, the Tax Appeal Tribunals, all of these also appeal from those tribunals lie to the Court of Appeal. But it does not mean that they have coordinate jurisdiction with, you know, the High Court. So the issue of jurisdiction now comes into play, and that might end up at the Court of Appeal, further delaying the process, you know, at the Code of Conduct Tribunal. And so that's why I had thought that now that the issues are the public domain, what should have been, if I were in that position, would be, okay, the matter is in the public now, do a petition to the NJC, and then I know the other members of the NJC, in treating that same petition, would definitely ask the CJN to recuse himself, and then look at the merit of the matter, head or tail. If you remember Justice Jumogobia's case, the judge of the Federal High Court, she was charged for a criminal misappropriation and then fraudulent practice as a judge. With that judgment in Justice Ngajua's case, she filed an application challenging, you know, the jurisdiction of the court, and she was left off the hook. But a petition to the NJC dismissed her subsequently, and then immediately she was dismissed, the EFCC took up the matter again. You know, so if you had said, look, I wasn't going to go in this route, and then because of that you refuse to take a petition to the NJC, the woman probably today will still have been working free. So that's the processes and procedures that I'm talking about.
Well, all of us are equal before the law, and if we err, we should be made to, you know, stand before the Court of Justice. Do we as a people, you know, do we judge matters on merit? It now takes me to the philosophy, and this is what we call the spirit and letters of the law. If you, the law, there's always, even for elementary law students, there's this consistent struggle between morality and ethics in law. And over time, ethics always prevail over morality. What happens is, that's the processes and procedures that I talked about. And morality, that's why in society, in other societies, what happens is the laws are hinged on moral values. And so laws are crafted to accommodate moral values. So at the end of the day, you know, there's a meeting point between ethics and morality, because if you're talking about morality, the law will be looking at the procedures. And that's why in criminal matters, the first step a defense lawyer takes is to file a preliminary objection to the charge. You know, look for loopholes. Now you're not talking about culpability. You're not talking about is the man guilty or not guilty. And that's why even in court, because also your constitution presumes you innocent. Even if I caught you red-handed, you're still presumed innocent until proven guilty, pronounced by a court of competent jurisdiction. And that word, competent, you know, also is very key. So these are all the processes and procedure. And that's why when you talk about this, you're talking about ethics of the law, you know, as distant from morality, moral value in the society. And so when the society is unable to build its laws anchored on moral, you're going to have a consistent battle between ethics and morals. And ethics will always prevail. And so now to answer your question directly, in the court of public opinion, it is easy to say, yes, this man, you've committed this offense or this crime, so go for it. But in the eye of the law, it's not that easy.
The eye of the law is you presume the presumption of innocence in his favor. So it is you that is ascertain that must prove beyond reasonable doubt. Reasonable doubt means that the man, any reasonable person who hears this story, the only conclusion that will come to his mind is that, look, this man did this. And also, once there is a doubt created in the mind of the court, it must be resolved in favor of the defendant. And so all of these are ethics, not moral. But for morality, it's a different ball game altogether. And so also that would lead me to another big area. How are some of these our judges appointed? You know, that's why when you look at Nigerian, you know, a public space, both the judiciary, the executive, and the legislature, how do we appoint? What's the pool that we draw from? Now it is fashionable for people to want to aspire to certain positions, not because of competence, but because, look, it's our turn to get, it's my turn to chop. And that's why you see when list of judges are released, everybody's looking for, it's my person there, who, you know, and then you see politics around the corner now, you see the do-or-die approach to it. It's not about competence. If we continue like that, no society grows, you know, in that part. The world is diversifying to a knowledge-based economy, and here he was still talking about, you know, looking for jobs, where you're trained to look for jobs and not trained to create jobs. And so you want to work under somebody as a lawyer, and from there, you want to lobby to become a judge. And if you know somebody that knows somebody, and then you're given a note, please, the bearer is from me, he will cope. You get there. The first thing on your mind is, how do I make a living out of this? Professor Yomi Oshibanjo, as Attorney General in Lagos State, sacked about 32 magistrates on the same day, and a few judges. The heavens didn't fall. Do you know why?
Why?
He sacked them.
Yes, because procedures were followed. What happened? When they came on board in 1999, he looked at the remunerations. He felt that, look, this was very poor. And if you need people, if you want to attract the best mind, you will need to do something about the remuneration and their condition of service. And they did that. After doing that, they now had to look at, you know, the ethical practice and values. And so they discovered that a lot of them were below board. And what did they do? It simply did, for the magistrate, it was within their purview. For the justices, it was within the purview of the State Judicial Commission to look into the matter and subsequently recommend to the National Judicial Council, which they did, and, you know, the heavens didn't fall.
Well, which takes me to what the lead counsel in the famous Ngajiwa versus Federal Republic of Nigeria case, Chief Robert Clark, Senior Advocate of Nigeria, said recently. He has spoken. He says, although the process, the due process was not followed because the case, his case, ruling he got, says that you have to remove the toga of a judicial officer, and that's going through the NJC before you can prosecute anyone. But he raises critical questions and concerns. He says this was done in this manner to expose the rot in the Supreme Court and the judiciary by the executive. So do you buy into that? Because he said there's no way that the Attorney General, for instance, doesn't know that he would not get a judgment by taking this to the CCT instead of the NJC, and that this was a deliberate move to expose the rot in the judiciary.
But at the end of the day, which one would pay you better? To expose the rot and allow these people remain, or take through the processes and at the end of the day, get them out of the system? Because first, who nominates, who appoint, how were they appointed into the system? Have we jettisoned that method of appointing? We're still on it. So what we're basically saying is that we're massaging the problem. And so it still subsists. And then secondly, if you expose the rot in the judiciary, this is not the first time people are exposing the rot in the judiciary. If you expose the rot and you leave it there and then you give them opportunity to cover it next time, does that solve the problem? Does the rot not still remain? Why don't you take a holistic approach to ensure that the rot is not only exposed, but it is removed, you know? And then you can now use that as a precedent.
But how would this be done without the question of interference, usurping of power? Should the judiciary not be cleaning its own house?
That's what I'm saying, that you can't, as an outsider, clean the judiciary as an agent, organ of government without involving the judiciary. And so the moment you get the buy-in of the judiciary, it becomes easy for you to gradually, like they say, the enemy of my enemy is my friend. Mm-hmm. And so you get the buy-in of, some, and then once you're able to cleanse a few, you can now bring in others to clean those other ones that are clean out the initial ones. But when you say, I just want to expose the rot, and you expose the rot, and it dies, and the man remains there as the CJN, is using the ethics and processes, then you have failed.
Too many technicalities.
Because there are some legal technicalities that are not statutory, while there are some that are statutory. The statutory ones you must comply with. So if you decide this is the non-statutory ones that the Supreme Court had consistently ruled not to allow to defeat the ends of justice. But if you say we want to expose, and so you think that the public will be able to browbeat, the CJN into submitting, to resigning. What if it doesn't? Why don't you, now that you have exposed, what will it cost you to take the right channel to ensure that, yes, while the public is browbeating, but you have taken the right process to ensure that you not only expose, but you cleanse. That's what will help society.
Well, talking about this process, there's so many professional loopholes, technicalities in the legal world or legal profession. The issue, they say, is that he should have been taken to the CJN, the NJC, National Judicial Council. Yeah. But the National Judicial Council is only empowered to try professional misconduct of the judiciary.
Do you see? That's also...
And this issue of his is an issue of a personal or public opinion.
You see, where the problem is all of these also are subject to judicial interpretation. If you ask me, I will say, look, yes, from what we have seen and heard, that there's a serious question and there's a doubt created, the mind of the public, against the person of the CJN, which ordinarily should warrant him stepping aside. But people are also going to read intentions into it. And people are also going to read processes and procedures. And so if you have a sit-tight, attitude, you create loopholes for that sit-tight person to want to sit tight. And then secondly, if you look at all of these processes that had been taken, everybody, including those that, like Robert Clark that you cited, that also supports what is happening, says, yes, the process is faulty. And so that that if you get to CCT, you would get justice, or that you will get conviction, or indictment, sorry, because the CCT can't convict, they only indict. And then, eventually, in challenging the processes, you might end up spending, like I said earlier, spending 1 year just challenging the process. Because now, with the ruling that the CCT gave yesterday, there's every likelihood that the defense team might go on appeal. And if they go on appeal and they ask for stay of the proceedings, and the proceedings are stayed, what happens? And then subsequently from the Court of Appeal, the matter might eventually get to the Supreme Court. And, while there is, even though the rule is that if it's a criminal matter, appeal shall not be, stake shall not be countenanced, but it can go either way. And then also, during the Justice Ayo Salami's issue, you find out that we had queried that there is need for the National Assembly to look at a constitutional amendment, look at the composition of the NJC. That's because almost 80% of the members of the NJC are nominated or appointed by the CJN, in his opinion, who he thinks are of questionable character. And so, if all of these members who has been nominated and appointed, and then the government says, look, we don't trust them to handle a matter that's of this nature, then it means that even the CJN, this NJC is dead on arrival. And subsequently, even if the matter gets to the NJC and it is handled one way or the other, the government would have followed the procedure but can still challenge the eventual outcome. And then another thing that is very funny and you know, interesting is that during the Justice Ayo Salami saga, the protagonists at that time are the antagonists of today, while the antagonists at that time are the protagonists of today. During that crisis, I remember also being on Channels TV with Professor Esesage, GT Ogunye, while we were moving from stations to stations to explain that the federal government, the step taken by the federal government at that time was wrong, to have hurriedly suspended Justice Ayo Salami without, you know, giving opportunity of fair hearing, simply because he went to court against the NJC. But the NJC made recommendation and the federal government hurriedly accepted that recommendation. But when the same NJC, against a sitting CJN, because if you remember, the matter was almost like a crisis between the President Court of Appeal, Justice Ayo Salami, and the sitting CJN, Justice Kassina Alu. And so, when the same NJC against Kassina Alu made the same decision to say, we have looked at the matter and we did not see where Justice Ayo Salami erred, so recall him. The federal government said, no, somebody's already there, so he cannot be recalled. And anyway, that the matter is in court, is sub judice. And with that precedent, some other lawyer, the new CJN now, Onogen, will be watching. And so everybody is saying, step aside, step aside. He will be of the opinion, what's the guarantee that if I step aside and eventually the process is looked through and I'm not culpable, what's the guarantee that the government will not use that same magic?
It's the magic.
Yes, it's government magic that was used against Justice Salami, you know, against me, because it seems as if the only intention, also going by Robert Clark, of the government is to browbeat him out of office, not minding the processes used, which for me cannot create a good society, better society.
And intentions are very critical in the legal world.
Very.
But with all the conflicting interpretations of the law, whose word will be final on this matter?
The courts.
Which of the courts? I mean, we've already had so many courts bantering back and forth.
That's what I'm telling you. That's why even the Code of Conduct Tribunal yesterday was not, you know, in unanimous agreement. You know, why one, it was of the view that, look, this is the Court of Appeal is already seized of the matter. There'll be need to adjourn sine die. You know, the presiding chairman of the tribunal was of the opinion that no, that they must go on. Why the third was in between, you know, and so, excuse me, eventually, like I said, if the matter goes unappealed, the Court of Appeal might rule on it either way. And then maybe eventually might get to the Supreme Court. And so once the Supreme Court makes a pronouncement on it, it becomes the final words of the law. And so that's why we say the law is what the court says it is, apart from the letters, apart from the ink with which it is written on the paper. So it's interpretation. Let me quickly give you an instance. Section 188 of the 1999 Constitution, before that talks about impeachment of the governor, before the interpretation of the Court of Appeal in Ladoja's case, the view expressed by most lawyers was, you know, even the opinions were also divided, was that once a governor is impeached, he cannot be challenged in court because subsection 10 of that section 188 says so. But the Court of Appeal, in its wisdom, in Ladoja's case, were of the view that no, you can actually challenge it because you have subsection 1 to 10. And subsection 1 to 9 lays out the procedures that must be followed. So it brings me back to processes and procedures. Yes. So it lays out the procedures that must be followed. And so if the procedures are not strictly followed, then you can invoke the provisions of subsection 10 to challenge what eventually happened. And that was how Ladoja was reinstated. And so we all know that in law, the law does not just look at morality and say, oh yes, the public opinion is, you know, it must also benchmark that morality on ethics.
Since it has quickly been turned into also a case for public court opinion, we see that opinions are clearly divided. Even outside the CCT yesterday, we had protesters for and against this issue. And so, you know, there's that issue of the substance of this case. And look at the alleged monies in those bank accounts, which The Senior Advocate of Nigeria, Robert Clark, also made assertions too. He said, as a Senior Advocate of Nigeria, he doesn't even think that he has up to $10,000 in his account. And by conversion, that's about 3.6 million naira Nigerian money using the parallel rate. If I use 305 or 306 of the bank rate, it will be far less than that.
Nobody gets 305 except you.
You know, but when you look at this alleged amount in the CJN's account, are they really amiss?
Yes, it's mind-boggling, truly. It's mind-boggling. And that's why, for me, I had thought that it would not be enough to just say we want to expose. You know, there should be there's a time you need to use some persons as scapegoat to serve as a deterrent to others. But when you just expose, knowing fully where the implication of the position of the law in all of this, you just expose and you go back to sleep, you have just treated, you know, you've massaged the problem without actually getting to the root of the problem. It's like we always say, when there is an allegation of corruption or bribery against a judge, there's a senior advocate who is a conveyor belt. You know, so that's why in some cases, like he said, some politicians, when they are preparing for their cases, they also keep money aside. I've had such, you know, requests. Some people asking me, can the judge be bribed? I say, I don't have access. It's so bad that some magistrates, even some judges, would not want, if you have a matter in their court, they wouldn't want to see you in chambers, you know, privately. They would rather you appear with the lawyer on the other side so that there won't be issues. And so with all of this, if we truly means well, if we truly want to clean the urgent table, there's need for us to look at the processes and say, how do we achieve this? And not just to expose, because exposing, what aim will it fetch us? And then, also, like I told you, you see, because we play politics with everything. Every issue in Nigeria we play politics with. Thanks also to the federal government, the way they handle their own matters. You know, if it's, Shomole recently said that once you join them, your sins are forgiven. And all of that, you don't make such statements and allow and tell people not to talk about them. And then when you look at the process and then the petition, where did it emanate from? You know, and so and then you look at the people surrounding the president also. Opinions are definitely going to be divided, you know, because you now say, even the morality that you're preaching, your practice, your style is not anchored on that morality. And so if you are somebody who is of high moral value, but you have, you know, all your friends are people of questionable character, then also there's a big question mark regarding your morality. So opinions are going to be divided. That's why I told you, unfortunately, those who were the protagonists on Josiah Salami's case are today the antagonists. The PDP then that were shouting, yes, Ayo Salami should be suspended, are the ones that are saying today that Onoge should not be, you know, should not be made to vacate his seat. The APC then, those who were in opposition, who were shouting, yes, Onoge is being witch-hunted. Sorry, Ayo Salami is being witch-hunted. Today are the ones saying, yes, you know, we need to expose the rot in the judiciary. Corruption and, you know, but you can't build societies like that. When the moment you give a loophole in processes to a defense lawyer, he will expose that loophole to his advantage.
So why do you think that the federal government has not withdrawn this to take the due process?
First and foremost, I think it will be a matter of ego. And then also, you noticed yesterday, even the prosecution lawyer was, you know, brandishing, oh yes, I have a right to ask for a warrant of arrest against the CJN, you know, and all of that. So when you look at the argument for and against, it's more about, I would look at it from an ego point of view, and then also that, look, we can achieve this. We are pushed so far. If we push it in the public space, it will gain traction. But forgetting that, you know, the public and not the judges.
Exactly.
You know, the public space is not evidence in court. Also, even evidence, there are processes and procedures for admitting evidence. Because, let me give you an instance. You have a matter, and the accused makes confessional statement, or the defendant, as the case may be, makes confessional statement. Do you know that the law also the first thing that defense lawyers do is to, when that confessional statement is to be tendered, this is a statement the man has made admitting, yes, I committed it. When it's to be tendered, the first thing they do is to challenge the admissibility of that document to say it wasn't voluntarily made, because a confessional statement by the provisions of the law must be voluntary. And that's the difference between the policeman abroad in saner society and the policeman here. I've been questioned by a policeman in London, and he was so kind and humane. And, you know, oh, do you care for a cup of tea or a cup of coffee? You know, just tell me. Because he knows that at the end of the day, the questions, whatever I say might be put to questions were they voluntarily made. Even though at the end of the day, it was a case of mistaken identity. But here, the man is, you know, charged in the court of public opinion, and evidence is already in the court of public opinion. And he eventually gets to court. The court looks at the processes and the procedure, how they were made, whether they were voluntary, and the court says, no, this statement were not voluntarily made. Look at photographs. The man was tortured, and at the end of the day, he admitted to, and the court says, look, you know, this statement cannot be tendered in evidence. And that's the only statement you have. With that, a man who probably would have committed a crime will walk away free, going back into the society to continue, you know, as a menace to the society.
Well, talking about public opinion, the general idea is that this case is politically motivated, and we're a few weeks to the election. Constitutionally, if there's a case against the CJN, who replaces him?
Yeah, I'm the next in line.
The next in line replaces him. And how is that process taken?
The NJC, same NJC, recommends to the president, subject to the supported by a two-third majority of the National Assembly, appoints. And then another big question is, all of this, if you look at, let me go a little bit into the issues. You ask yourself, what happens to all the screening agency? We're not talking about declaration of today. We're talking about the declaration of 2016, even though there's no time limitation to, you know, crime. But I think also some people, you know, in the clearance agencies, investigating agencies, also ought to be answering questions. You know, how come you did not see through this? You know, that this man was cleared, you know, to go, that he had complied with the processes.
Exactly.
You know, and then, secondly,
including at the National Assembly.
Yes, at the National Assembly also, because it was cleared by the Senate Committee on Judiciary. You know, and then also, when you ask a question about the fact that the elections are, you know, very close. If it were a society anchored on moral, ethical values, nobody would be talking about the time. Irrespective, even if it's 2 days to the election, a crime has been detected, presumably committed by somebody, and then the law will naturally take its course. But because we look at the body language of Mr. President, where is he looking at? Oh, no, this person should not be touched, this one should be touched. And so you create a divide where people now begin to hold their own. And then also, the next question will be, oh, where is he from? Is he from the north? Is he from the south? You know, so when all of this begins to happen, it takes away the meat of the allegations, it takes away the merit of the case, and then we begin to deal with the pedestrian. And even when you discuss the legal perspective of it, people will always view it from sentiment. Oh, it's because you're close to this person, or because you're a lawyer that you're looking at it from this point of view. But law does not encourage mob action. And if you resort to mob action, you know, you're definitely not going to have your way and your say in court. Let's
look at the issue of asset declaration, because we keep coming back to this when it comes to public officers in Nigeria. The head of the judiciary is under that. One of the 6 charges borders on asset declaration. When you look at the president of the Senate, Saraki, was also the issue of asset declaration. We've seen other top officials come back to this. Why can't we see an end to this? Why do we keep coming back to this issue?
And this one, you know that there won't be an end to it. For as long as we treat politics as an end in itself, we will never see an end to it. As long as we are not a society of job creators, but job seekers, you will never see an end to it. As long as we are not genuinely fighting corruption, but we fantasize about corruption, you will not see an end to it. Why do you think some people are leaving their party and moving into the ruling party? Is it because of the ideologies, or because of the belief, or because, oh yes, the president is so good? No, it's about bread and butter. What do I gain? And why do you think some people will leave the ruling party on the ground that they were not given appointments? Oh, I worked for it, but I wasn't compensated. Appointments are about compensation. It's about, that's where you see people who could barely feed join politics, and they are multi-billionaires, no question asked. That's where, you know, somebody said that when you talk about the American dream, you talk about sportsmen because you know they earn, you know, so fantastically well. Not politics, but when you talk about the Nigerian dream, it's about politicians.
Sorry, let me ask you this follow-up, because I guess you need to educate us on what the law says about asset declaration by public officers. Because when you go to the executive, it's repeatedly not done by the president and the vice president. Does the law omit those set of people from declaring their assets?
No. They declare their assets. They do declare their assets. The question is, do they declare it publicly? They declare their assets. You declare as you're coming in, and then you declare as you're exiting. But you find out that most of them don't even declare when they exit. They only declare when they are coming in. It took Yaradua to be the first to declare publicly, and he encouraged others to so do. You know, even the current president declared publicly halfway, and then his vice, and then some people said, look, you need to go the whole hog. Then we started another round of sentiment. Oh, yes, the law does not say he must declare publicly, provided he declared.
What does the law say?
You know, you would declare, not publicly.
Okay.
Yeah, because it's supposed to be between you and the agency. That's where you look at the Section 3, the functions of the Bureau, to receive assets declared. And then also, if for like judicial officers or for public officers whose office are not tenured, you do it every 4 years. You know, you declare assets every 4 years. But the nitty-gritty now is that, do you declare, if you have an account, for example, do you declare everything in the account, or you declare that there is an account with so-and-so bank? All of these are for court to interpret. And then, also, you find out that most of our laws are observed in breach rather than compliance. And because, you know somebody that knows somebody that knows somebody, so you don't comply. And when you don't comply, you know, nobody does anything. And the day somebody is now caught, to be used as an example, there's, you know, a cry from all quarters. And that's why the law, justice should prevail if even the heavens will fall. There's no need shielding certain persons, because once you do that, you're going to create, you know, like I said, a divide, where some people will be pointing accusing fingers, most especially when those who are not doing it are a majority. And so asset declaration should be a compulsory, it's ordinarily a compulsory thing for every public servant. And then another thing also from the same code of conduct is the fact that, you know, even gifts, when you receive gifts, you're supposed to declare. And also, secondly, when you are a pension, you know, staff, you can't take another pensionable job. Like, take, for example, you're a former governor, earning pension. And you cannot, and then you now become a senator. You're still earning salary, and at the same time, earning pension. That's a breach of code of conduct. But how many of them? You have, as we speak now, the Senate is gradually becoming a retirement home for former governors. And, you know, many of them, you know, created laws that, you know, gave them fat pensions in spite of the poor nature of their states. And today are still collecting allowances as senators. And nobody's talking about all of this. So when you have societies such as that, and you have people like that at the helm of affairs making laws for you, you're going to have selective justice. And selective justice in every society will create the kind of noise that we're having now.
Well, this case is gradually becoming a media attraction.
Until another one comes.
Until another one. Yesterday was the second hearing of the case, and the Chief Justice of Nigeria, Walter Onagen, was absent for the second time. Is he taking advantage of the ex parte motion?
Yes, I think so. He's taking advantage of the processes and procedures. And that if you're challenging the jurisdiction of a court, that your presence is necessarily not needed, except pleas to be taken in criminal matters. And so, that's why when you create loopholes, I say this
there are too many in law.
When you create loopholes, and that's why as a lawyer, even as a prosecuting counsel, you look at the case of the defense, what likely would come up. Even though the law also tries to limit surprises, we say you front load, or even in civil matters, just like you have in criminal matters, you say you must, attach your proof of evidence, avail the other side of the opportunity of seeing what you're bringing against them. But you don't create loopholes. Even in drafting of charges, there are issues that are very technical that the way you couch your charges also might go a long way in determining whether the charge will be sustained or otherwise. And so for that, like I said, the first thing smart defense lawyers do is to raise a PO, preliminary objection, we'll call it PO, and then challenge jurisdiction, challenge the competence, challenge charge, but another very germane issue.
All in a process to elongate the matter.
Yes, if you give them the opportunity to. But another thing that we don't do here, in the UK, you don't file frivolous applications to elongate processes. If you do that, the bar is going to look at the processes, because they say when a judge sits on trial, the judge is on trial. When a lawyer is trying a matter, also the lawyer is on trial. You have disciplinary measures that are taken against such lawyers to determine if truly he abide by the ethics of the profession. But here, they are observing breach. And that's why a defense lawyer defended Ibori here. But in London,
in the UK,
in the UK, the lawyer that defended Ibori, including his wife, and they all went to prison with him because they look at the processes. Did you suppress evidence? Did you intentional? All of this. If we do that here, a lot of lawyers by now won't be practicing law.
Okay. Why don't we do that here?
Because we have a compromise system. Everybody, we are all part of the problem. We all have our hands in the pie. Everybody wants to find a way to cut corners and make money. Thanks to government also, where there are no social safety nets. So you're on your own.
Interesting that you say that. You've said the courts will have the final say in this one, but let me ask your personal opinion. What would be the surprise for you in this case?
I have been too long in practice to see surprises because in law, I really don't, I'm not the type to swim with public opinion, I'm already seeing a lot of, faults here and there on both sides. And so either way, I won't be surprised.
Okay.
I won't be surprised. But for a lot of people, the surprise would be that, the CJN would walk home free.
Okay.
Well, we're going to have to leave it at that. LIBOROUS OSHOMA, constitutional lawyer, speaking to us on the trial of the Chief Justice of Nigeria, Walter Onogen. Thank you for being here this morning.
My pleasure.